But it was presented that in the place where the accident occurred, a an owner driver will not be liable for the injury of a gratuitous passenger, somebody you gave a lift. And so the US state court was to determine that issue, the issue of whether the owner driver should be indemnified or not. So if the court was applying lex loci delicti commissi, it will say, no, firstly, the court would say this is a general issue of tort. There is no argument about that. What is our connecting factor for tort? If our connecting factor for tort was lex loci delicti commissi, it means that it is the law of that Canadian territory that we are going to apply. And we are going to say, well, Mr. Plaintiff, the defendant is not liable to you because Canadian law, the place where the accident occurred, actually exonerates him from liability. Okay? But that particular state does not apply lex loci delicti as its conflict rule. It applies instead another formula known as proper law of tort or governmental interest. And so by the time it applies its own conflict rule, it arrives at the conclusion that the American state, which is actually the social environment of the tort, because it is the state from where the parties departed, it is the state where insurance are based, it is the state where the car was registered, and all of that will be the actual applicable law. So you will find a situation where another state court that would apply the conflict, the connecting factor, lex loci delicti commissi, would have arrived at Canadian law being the governing law. While this particular US state court, relying on a different connecting factor, arrive at the state law to govern the dispute. So that's for tort. You come to questions of marriage. Somebody files an action before a Nigerian court and he wants to determine validity of his marriage. The judge will want to first find out what are his issues, on which basis he wants to nullify the marriage. Family law experts will categorize issues upon which you can nullify marriage into two broad categories: formal validity and the one that we in conflict of law call capacity or essential validity. The connecting factor for the two are not the same. If the issue in dispute, the issue that the party who wants to nullify the marriage has raised, falls under formal validity, our conflict rule says apply lex loci celebrationis. It is the law of the place where the marriage was celebrated or done that you will apply. So you might find that the parties are not even domiciled in statewide. But if the question before the court falls under formality, like the question of whether the time they went to the registry was proper, whether the non-publication of ban should invalidate the marriage, or whether the fact that the administrative minister was not licensed to administer marriage oath etc., etc. In all of those issues, you will be looking at formality. A judge with an understanding of both family law and conflict of laws will see the issue as formality. And if the fact throws up that the marriage was done statewide, he will say it is statewide law that will govern that issue. You might then find that what you are thinking had nullified the marriage will not apply because state A's law does not require it. On the other hand, if you are talking about issue of capacity, like the age of the spouse when they were marrying, like prohibited issue of prohibited limit of affinity and consanguinity. You know that state laws can be very different in those areas. You can have some state laws that will say that if you are uh, first cousins, you can't marry. Whereas many other states will permit first cousins to marry. You can have state laws that will say that you can't marry your wife's sister or your husband's brother. Okay, and you can have others that might permit it. So if the question is capacity, you will now not look at lex loci celebrationis. You look at lex domicili. We use domicile here. Some countries use nationality, but we will use domicile. So you will now apply lex domicili. Look at where the spouse are domicile and apply that law to determine whether they had capacity to marry one another or not. Okay? So that is the technique we want you to talk about. We want you to highlight the different connecting factors for different subject areas. So for property, it's usually lexitus, even though lexitus will take a variety of meaning depending on the type of property you are talking about. Okay? For contract, I have told you. For marriage, depending on the issue, it's either lex domicili or lex loci celebrationis. For succession, you want to determine, you suddenly discover that the disease the disease has property across the globe, and has heirs who are depending on the laws of the different countries where he has property, especially if the property is movable. So are you going to say that, well, this share that is based in Spain, what does Spain law say should happen when it comes to the question of inheriting the disease? Or are you going to say that is cars that are located in Benin Republic? You want to ask Benin Republic law, what does Benin Republic law say about inheritance? You definitely are not going to be applying different laws of the different locations of the movable assets. It is a status issue. You must apply the law of the last place of domicile. Okay? So, broad categorization, status or succession, connecting factor, domicile. Only that in this case, you have to understand that in the history of the life of a disease, it might have acquired different domicile. Okay? It is the one that is deemed to be the last domicile he had acquired before his death. It is that law that you are going to look at to determine who is able to inherit it or who is not able to inherit it. Okay? So that is the technique that we want you to be able to talk about. Can we have the next presenters still under technique and process?
Yes,
The
sir.
next presenter are going to talk to us on some special issues, some issues that make conflict of laws very technical, under technique. Okay? So are the presenters ready?
Group
Yes, sir.
6.
Okay, so let's have you.
6. Call your members for attendance.
They were doing some work. Okay, guys. He was doing some work here. So you can go and stop the work. You can go and change the light. It's back. It's back. Yes. Ask him whether he still needs to do the wedding he was doing. And change to NEPA. Change from NEPA. Sorry, gentlemen. Oh yeah, let's go. Let's go.
Group 6. Group 6 members, are you here?
Yes, we are here.
Please, the group leader should talk to the members that worked on the
So
paper.
what are you discussing? Which of the technical issues are you discussing?
Good evening, sir.
Good evening. There are 4 technical issues we
Yes, sir.
normally discuss.
Our topic
Is it all the
surrounds
4 that is
characterization.
it all the 4 that they gave to you?
Yes, sir.
Okay.
So
Can
our
you
topic
really
evolves
discuss all the
around
4?
characterization, connecting factors, and applicable laws for different subject matters on the basis of locus regit actum, the problems of characterization, and incidental questions, demonstrating the Anglo-Nigerian position, if any, out of the different options available. We'll also be discussing the problems of time factor and renvoi,
Okay.
demonstrating the
The correct
Anglo-Nigerian
pronunciation is
position.
Rouvoir. Is
Rouvoir.
Rouvoir.
Thank you, sir.
Eh?
All right, sir. If
Professor
any, out of
Agbede
the different
corrected me
options
when I was
available.
calling it Renvoy in his class. It's Rouvoir.
Okay. All right, Rouvoir. Thank you very much, sir.
Okay.
So
Okay.
I'll be calling out my fellow colleagues. The first name, Ajayi Ejide Kofrola, which is myself. The second name, Ajishe Butu Adeyemi John.
Is he present?
Are you there?
Present. Yes, I'm
Captain,
present.
please be marking.
Yes, present. Starting.
Agbonjato Stanley. Sorry for the way I'm pronouncing your name, so.
Present.
Are you
present.
there? Ajayi Adeyinka Anyotunji.
Yes, I'm here.
Adebayo Abiodun Olaniyi.
I'm present.
And the last name, Folakemi Femi Jemilohun.
I'm present.
All right, thank you. That will be all. The next presenter will speak now.
Okay. See, in order not to waste our time, go straight away to, because you see the starting point is all that we expected the first set of people to see. That's your starting point of the different
Characterization.
categories and connecting factor. That's all we wanted them to see. So this technical problem, characterization is still a technical problem.
Yes,
why will it be a technical problem? Address us on that. The presenter, address us on why characterization can be a technical problem beyond the ordinary.
Sir, please, what group is presenting, sir? Let them say what group is presenting.
Group
Thank you, sir.
Group 6.
Group 6.
Group 6.
She said she handed over to someone now, and I said the person should start from characterization as a technical problem. Characterization is very simple, but it can become a technical problem. How can it become a technical problem? And what would the court do if it becomes a technical problem? Quickly look for where you discuss it in your notes and tell us what you said.
Okay, good afternoon, Prof. Good afternoon, class. So, um, regarding my paper, I categorized, regarding our paper, speaking in relation to characterization, we believe one of the problems of characterization, various schools of thought have been propounded: characterization by the lex puri, characterization by the lex corset, the primary and secondary classification. But of paramount to conflict of law techniques is the characterization by the lex puri and characterization by the lex corset. So basically, when a forum court is thrown with a question or an issue involving a foreign element, it does not just put the cart before the horse by resolving the dispute immediately. It needs to, like you earlier said, it needs to place the fact in issue before a certain a legal edge. And so, the major problem we believe that comes with characterization is sometimes which law would the forum court, considering that sometimes the issues can be multi-jurisdictional. It could involve, it could cut across various legal systems. So the forum court would have to ask, do I apply the law of the forum, which is the lex puri, or do I apply the law of the lex causae, which is the law governing the cause? So, and in our own humble reasoning, we believe that generally the lex puri, characterization by the lex puri actually gives the court autonomy. Considering that the court is the master of itself, and in trying to characterize, the forum court is not characterizing through its own laws does not necessarily mean that it's the domestic laws is what will finally determine the issue. It only helps the forum court, determine the final law. And one thing you also observed is that if we are to characterize or categorize a legal issue by the lex causae, the problem it throws is that the forum court at that stage, at the early stage, cannot characterize by lex causae, because the problem would be that it will be putting the cart before the horse. It's regardless of whatever characterization, regardless of whatever law it finally arrives at, it needs to make resort to its own forum laws. And so we believe the principal advantage that the lex puri approach has is that it gives judges, it gives the forum courts, some sort of sovereignty and control over determining the issue. And we also noted
Okay, sir. I will change my style so that we can make progress. The question I ask you, you have been hovering around it without answering it. If it were to be an exam, I'm a very generous examiner. I would have given you, say, 40 to 50% of the mark for that question. I told you that I asked you, when can characterization be a technical problem? Characterization can be a technical problem if the lex causae and the lex fori do not categorize the issue the same way. If the lex causae, by the way, is the applicable law, it's supposed to be your final answer. If you follow the technique as we have stated it, you are supposed to categorize. You are supposed to look at the connecting factor related to the category, and that connecting factor is supposed to give you the applicable law. Okay, that is the formula we said in the first lecture. Now, characterization becomes a technical problem when you will do that, because naturally you will do it according to the forum. You will do that, then you will arrive at an applicable law, and on getting to the legal district of the applicable law, you will see that the legal district does not even categorize the issue the same way the forum has categorized it. Example, Machado and Fontes. In the case of Machado and Fontes, which is a conflict of thought case, a libel was published in Brazil. Now, you know that there are many countries of the world where libel is not a tort, it's just a crime. Okay? And you say the connecting factor, an English court would categorize libel as a tort. And English covering rule will say apply lex loci delicti commissi. The libel was published in Brazil. So English covering rule will direct us to apply Brazilian law. On getting to Brazilian law, which is the lex causa, you find that libel is not a tort. So don't you have a technical problem? You have a technical problem. The simple technique that we have taught you cannot answer the question, because the lex causa will categorize the issue differently from how the lex ori will categorize it. So characterization, which you ordinarily would be a very simple thing, had now become a problem. Okay? Fortunately, you will find that legal systems of the world agree on broad categorization in 95% of the cases. But in the remaining 5% where one country will categorize the matter as one thing and another will categorize it as another, we have a technical problem of characterization. And that is when all these different methods of characterization become an issue. And you start talking about characterizing by the lex ori. Characterizing by the lex ori is what you do in 90% of the cases. Because you cannot begin to imagine that what is a tort in your country will not be a tort elsewhere. But where you have problem is when you complete the process and it takes you to the law of statewide, and you find that the law of statewide does not even look at the issue as an issue of tort. That's where you have problem. Okay? Then characterization by the lex causa. That is the one he was trying to talk about. That is even a non-starter. Because it is the technique process that will show you the lex causa now. So how can you put the cat before the horse? How can you characterize according to the lex causa when you do not yet know the lex causa? So some people came and said there are other ideas. Some people say use comparative law, use fair media, use all of that. Okay? If their paper on the issue is not illustrating enough, take any basic text. Okay? They will tell you all these different methods of characterization and all of that. The final answer is that you can't find any overriding method. Okay? At the end of the day, judges will just do what they think is the justice of the matter. Okay? So let's move to another technical problem. Don't mind me that we are cutting it short, because this area is very technical and we need to get it and we don't have time. So that is technical characterization problem. Let's move to incidental. Is it incidental question that you treated next? Hello? Hello, sir.
Sir, it was locus regit actum. After the connecting factor.
Locus regit actum is not an issue. Locus regit actum is one of the explanation you give for connecting factor. Locus regit actum just means that in most instances, you want to have regard to the law of the place where an act occurred.
Yes.
But in status cases, locus regit actum does not happen. I've given you the instance of a man whose estate is an issue for inheritance. You cannot say you apply the different laws of the location of his movable assets. You must apply only one law. And so locus will not be the determinant. Domicile will be. Do you understand? But in subject areas like title to property of a living person, not a deceased person, or thought, okay, or even formality of marriage, locus regit actum will govern because you are formulating connecting factor on the basis of where the property is, where the event occurred, etc., etc. That's what locus regit actum generally means. It is not a technical problem. It is just a way of explaining connecting factors, which the presenters of paper one should have talked to us about. So the real next technical problem is the one we call incidental question. So what did you say about incidental question? Who is going to present incidental question to us? Hello?
Please, hello, Prof, because we had various contributions. So I believe the person who wrote on incidental question, I mean, it was a collective work, so the person will be better placed to speak to it. Please.
Okay, so let the person who spoke on incidental question, who wrote incidental question, let him present what he wrote.
Good evening, sir.
Yeah, good evening.
On preliminary and incidental questions, our paper looked into the fact that when dissecting matters with foreign elements, such as with conflict of law cases, the court is sometimes faced with incidental questions which must be addressed before the main issue. And in illustrating the concept of incidental questions, we examine Gottlieb's hypothetical, which mirrors the facts of Lopitos versus Krima, where a Greek national died without a will. He was domiciled in Greece and had left goods in England. The wife of the Greek national then brought a suit in England claiming to be entitled to a share of the property. Under Greek law, the wife was entitled to share in her husband's estate. So then the question arose in the proceedings whether the wife was, as she claimed to be, really a wife of the Greek national. Now, by the rule of English conflict of laws, which was the law of the forum, text fori, the wife was, as she claimed, the wife of the deceased person, as they were married in a civil ceremony. And so by English law, the marriage was valid because the English conflict rules designates the law of the place of the marriage as the law determining the formal validity of the marriage. But by Greek conflict of laws, the law which is the law of the deceased domicile, the validity of the marriage was to be determined by the law of the person's nationality. And since the claimant was Greek, Rather, the deceased and a priest was not present at the ceremony as required by Greek law. The marriage was void. Now, in that situation, the principal question was of succession. The English rule of conflict of law selects the law of the deceased person's domicile to determine who shares in the estate. And by that law, the wife is entitled to share. The incidental question in that case, an incidental question, as you have said, arises naturally in the course of proceedings, was that of the marital status of the claimant to the estate. Was she or was she not the wife of the deceased? By the law of the forum, which is England, this issue is determined by the lex loci celebrationis, which upholds the status of the wife, while under the law governing the main question, which is succession, the marriage is void because it does not comply with the requirements of the claimant's nationality. Thus, we have a conflict of the conflict rules of the two countries relating to the incidental question. The court is in such circumstances faced with the question of choosing between the law of the place governing the principal issue, where it has elected to apply the conflict of law rules of the Lux Scotia, and its own conflict of law rules. It is noteworthy that an incidental question may lead to further incidental questions, all of which the court may need to fully address for the fulfillment of its mandate to decide the principal issue. The problem of incidental questions lies in the added layer of complexity, as courts must determine not only its choice of application of the lex fori or lex scotia to the principal issue, but a further choice of law rule may be required to answer subsidiary questions affecting the main issue. And we must also consider further intricacies where many jurisdictions are involved. Now, Gottlieb further gives scenarios in which a court may face difficulty in addressing incidental questions. There are 7 scenarios. One is where there is a convergence of the where there is a convergence of the choice of law rule on an incidental question, but the forum applies rule voir and the lex scotia does not. Another circumstance is where there is a convergence on choice of law rules on an incidental question, but there is a divergence in the characterization of connecting factors. Scenario 3 is where there is a conflict between the choice of law rules governing the incidental question. Another scenario is where there is a convergence of choice of law rule of the forum and the jurisdiction governing the principal issue, but a difference in their respective characterization of the incidental issues. Difficulty may also arise where there's a convergence of choice of law rule of the forum and jurisdiction governing a principal issue, but the lex scotia would apply its domestic law. Circumstance 6 is where the choice of law rules of the forum and the transmitting state, that is the state said as the lex scotia and applying rule are the same, but the transmitting state applied not its own choice of law rules, but the choice of law rules of the selected domestic system, which differ from the forum. Circumstance 7 is where the choice of law rules of the forum and the finally selected domestic system are the same, but the transmitting state applies its own conflict rule to the incidental question. That is what our paper covered on incidental question.
Okay, so let's discuss it briefly. You got the issue. You discussed the issue. Okay, but maybe your style is a bit more technical. Okay, you people should just go to one of the basic texts, especially Morris. He gave a formula for when an incidental question, technical problem would arise. Basically, the court would have categorized the issue and arrive at a connecting factor, which has given it the less consider. But a sub question would then arise, which we have called incidental subsidiary question. And the issue here is, do we answer this incidental question by the substantive law of the lex causa, or by the conflict rules, or do we go, sorry, let me pick this call. Sorry, let's go ahead. I was the one explaining. So there is a main question, and you have applied technique process, and your technique process has directed you to apply the law of state A. But a sub question now arises. And what are you going to do? Are you going to say that since we have arrived at state A as the lex causa, let's just apply the law of state A? Or you are going to say no, because this issue could have arisen as a separate, as a distinct and substantive conflict of law issue. Let's apply the conflict rule of the forum. Or, since we have arrived at a lex causa, let's apply the conflict rule of the lex causa. So, the formula that Maurice gave is more straightforward to apply than the one that whoever you were reading gave. Okay? But we can look at what your literature says and compare it with what Maurice says. Maurice says, for there to be an incidental question problem, there must be a principal or substantive or main issue. And after you have applied the technique, you would have arrived at the lex causa of the main issue. The incidental question or the subsidiary question is a question that would have come on its own on a different day, but it has now come in the context of determining the main issue. And so countries' conflict rules might have different approach to how you go about it. And the most important thing about the different approaches is that some countries might surrender the incidental question to either the substantive law or the conflict rules of the lex causa. Others might say, no, this is a question on its own. We are going to subject it afresh to the conflict rules of the lex ferrae. She gave an example which is very good. But the typical example I normally give to drive the issue home is our case of Fonseca and Passman. Okay? And the other one. In all of these cases, marriage was not the issue. There were cases where inheritance was the issue. Okay? The disease had died. The question is whether or who is entitled to inheriting. The court will normally say, if it's a succession problem and the assets are movables, it's a status issue. Apply the law of the place of domicile, the last place of domicile. So you set out the technique process and you arrive at state-wise law. It is state-wise law that will govern. Then there is a question, just like you said, of yes, state-wise law govern. But is Mrs. X, who calls himself the deceased wife, and is ordinarily entitled, if he was truly the deceased wife, by state-wise law to inherit. Is he really the deceased wife? In Fonseca and Passman, the question was whether children of a marriage who were the biological children of a particular lady were entitled to inherit the disease. The question of whether the lady was validly married or not then crept in, because that will basically determine the right of the children or the woman to inherit. The connecting factor for determining inheritance or succession was or is lex domicile. So if the man died domicile in Portugal, it is Portuguese law that will govern his inheritance. Okay? Now, the next question is, Miss X, is he married to the man or not? If the Nigerian court set that question afresh as a conflict rule issue, as a conflict issue, they might find that the issue thrown up to challenge the woman's uh, marriage falls under form. And our own connecting factor, we use lex loci celebrationis. Of course, if the issue falls under incapacity, it is the same lex domicile that we will use. So, are we going to simply ask Portuguese law, Portuguese internal law, was this woman married to the deceased Portuguese? Or are we going to ask of our conflict rule, what is the applicable law to govern the question of whether this lady was married to this man or not? So, the conflict rules of some countries will direct them in that circumstance to ask the question as a fresh question and subject it to the conflict rules of the lex ferrae. On the other hand, some countries' conflict rule will tell them that, look, you have already gotten the lex causa of the main issue. Apply either the substantive law of that lex causa or its conflict rules to determine the question of this subsidiary question. So that's incidental question. Do you understand? Then the textbook will now go on and look at cases and show you instances when it does appear as if what the court would do was to subject the incidental question to the conflict rules of the lex causa. And other cases where they will ask the question as a fresh question and subject it to the conflict rules of the lex fori. Okay? So it's a technical issue, but understand it. In the LLB class, we will tell them that don't look at the cases because you will get confused. Just know what an incidental question is and the conflict technical problem it throws up. Okay? We expect an LLM class to progress further by looking at the cases that are normally cited and be able to tell us that under Anglo-Nigerian conflict rules, this is the way we treat it. Okay? So go back to basic tests before you start reading articles and understand what the basic tests are presenting as the approach of the English court. The approach of the English court, by virtue of our reception of English common law, will be our approach. Okay, but you will find that most of the cases, some of the cases will corroborate the position that the incidental question, that is that subsidiary question that arose in the context of determining a main issue, will be submitted afresh to the conflict rules of the forum. While in a few cases, you will also see that what the court actually did is only compatible with surrendering to the lex causa, either a substantive law or its conflict rule to determine the incidental question. Okay? Is it clear? Asking whether it is clear is a tough question for me because you will say it's not clear. Let's move to, just go and read. Go and read. It's an LLM class. Those who have done conflict of law in LLB will find it easier because we normally spend more time explaining all of these things. But if you read a basic text like Morris, you will understand it. You can then progress from there to a more serious seminal articles, and you can form an opinion as to what is our own practice on the issue. Okay? Is it clear? Can we move? We cannot finish the 4 today. No way. You can't finish the 4 today. So can we take the third one and leave the last one till next week? What is the third one you discuss? Hello? Hello, gentlemen.
Hello, sir.
Hello, sir.
Yes,
We're
what's the
here,
third
prof.
one? What's the third one you discussed? Time factor? Is it time factor or Ruva?
Hello, prof.
Yes.
Is another group that is supposed to talk about the problem of
Okay,
time
you
fasting.
discussed only 2.
Group 7.
It's group 7 that we discuss what?
Group 7 were the one, Group 6 were the one that discuss on characterization, connecting, and problems of characterization. Group
Connect.
and connecting factor. Group
Yes.
7 is discuss on the incidental questions, Anglo Nigerian position. Then the
Oh, okay.
problem of
So you divided it into the technical issues into three.
yes, sir. You said we should divide that particular topic into 5 because it's wide.
It is. It
So
is. It is. I thought that it's only one paper that is presenting it.
no, sir.
Okay. Okay. So what else do you want to tell us? Group 6. So if you discuss, so you didn't even discuss incidental question. That's what you are telling me. No, you discussed it now. She talked
We
about incidental
discussed.
question now.
Yes. Yes.
So you did incidental question uh,
Characterization.
and characterization.
Yes. Yes, Prof.
Okay. Is there any other thing you said that is of interest? What cases do you look at? Of course, the discussant gave us a particular case. Is there any other case you analyzed on incidental question? Is there any other case you analyzed on incidental question?
No, sir.
Okay. Okay, the class member should go and look at basic tests. There are some cases normally discussed in basic tests. I have my Morris here. I don't know whether Okoli and Opok, whether they discuss cases. You should look at whatever it is that they said about incidental question. At the end of the day, I've told you what the options are. Some countries will say, look, don't go back to the lecturer for anything. You have already arrived at the next question. So even this sub question, determine it according to the next question. Either according to substantive law of the next question, or at worst case scenario, according to its conflict rules. But some countries' approach is to say, no, this is a question that could have arisen on its own. And we have a conflict rules for it. They will then subject the question to their conflict rules. And you may then find that their conflict rules may lead them to a different applicable law, which will not be either the substantive law of the lex concern or agree with the conflict rules of the lex concern. So if the lex concern and the lex oral have a different conflict rules, okay? For example, in the example she gave, some countries will use nationality, some will use domicile. So if you subject the particular question of status to the conflict rules of the forum, and the conflict rule of the forum says you should apply lex domicili. If the lex concern is not the domicile, then the conflict rule of the lex foreign will be giving you a different lex concern for the main question, for the subsidiary question. But like I said, some cases, some countries, their own approach will be, we have surrendered everything. We have surrendered the main question to the lex concern. Let's use the conflict rule of the lex concern, or even in substantive law, to determine this subsidiary question. Okay? So any question? At the rate we are we going to finish? After technically, we have not even done personal connecting factor. Don't be seen. We have not done exclusion of otherwise applicable law. Okay. We will be there. Next week, any other topic on this technical problem, we are going to have them. So, what is Group 7's topic? I don't want to preempt the group by discussing their topic before they have opportunity to present. Otherwise, I would have gone ahead with either time factor, and the time we have here now would not be sufficient for them to present. So, what is Group 7 topic, please?
Group 7 topic, they are supposed to talk on the incidental question, the Anglo-Nigerian position.
How
And
about the Group 6 has already spoken about incidental question? Okay, quickly, let them round it up
then,
to 15 minutes. Is it only incidental question they are going to talk about?
no, we have the problems of time factor. That's for group.
Okay, so they are talking about time factor and incidental question.
So time factor
Okay.
is group 8. Time factor is group 8.
For group 8. Time factor is for group 8. Ordinarily, group 6.
Okay. You know what we are going to do? I'm going to give each of you. I'm going to give you Group 7, who is talking about incidental question. I'm going to give you another 15 minutes because everything you want to say I've already explained. But let's hear you so that you will not lose mark for not presenting. Then after 15 minutes that you have done that I'm talking of next week. After your 15 minutes, we'll give time factor a maximum of 30 minutes. Then
Okay, sir. Thank you, sir.
That's next week. We'll give Rubua a maximum of 30 minutes. And we'll give Rubua a maximum of 1 hour. They will speak for 30 minutes and I will explain for 30 minutes. The incidental question, we'll give them 15 minutes to see whether they have anything that is different from what we have said, or they have gone further to tell us what the cases are saying, which is what Group 6 did not do, because they also spoke about incidental question. So, then time factor, they will present for 15 minutes and I will discuss for 15 minutes. Then Rufua, they will present for 30 minutes and I will explain for 30 minutes. So with that, all the technical issues will be finished next week. So that subsequent week, we will talk about exclusion of otherwise applicable foreign law and personal connecting factor, 2 topics. That is the upper week. Okay? Please, time is against us. We have to move fast. Okay? If I had known that incidental question is in another paper, I would have arranged for it to be presented before I spoke. Okay? But now that I have spoken, unless they are ready to lay it out for us in 10 minutes, can they talk to us about the cases they look at and what happened in the cases?
We are not ready yet, sir.
Have you submitted your paper?
No, we are not told
sir.
to submit. We are not told to. We are not told to. We are not told. We are not informed that we are presenting today, sir.
Okay, all the remaining 3, please, your paper must be ready by next week. Any group whose paper is not ready, I will just discuss it. And I don't know what I will do with their seminar presentation if they submit later. Is it clear? Anything
Very well,
on
sir.
technique We are going to finish next week. So we have
Very well.
3 presentations: incidental question, time factor, and RUVA. Next week, 15 minutes for incidental question, because everything we want to say I've said. If you have not finished your paper, just concentrate on the aspect of the English cases and whether you can say that consistently they have been adopting the option of resubmitting the subsidiary question for determination according to the conflict rules of the forum, or they have consistently been saying that the less costlier will determine everything. Okay? So that's what
Okay,
we
sir.
want to examine the cases and see what they are saying. Okay?
Okay,
15
sir.
minutes, you do that. Then your group 7 or group 8, talking about time factor. We give them 15 minutes to talk about time factor, and we discuss 15 minutes. Group 9, talking about RUVA, we give them 30 minutes, and we discuss for 30 minutes. So see you next week.
Group 9 is talking about exclusion.
Exclusion is a separate topic. It's not under technique.
Yeah,
So
but that's group 9 is not doing technique.
group 9 is not doing technique.
No, sir.
So that
That's
means
right.
it is group 8 that is doing both RUVA and time factor.
Absolutely.
No, no,
Okay,
no, sir.
No, sir.
group
Is
7
group
is
Group
doing
10 is
incidental question and time
adding
factor.
Renova.
What?
group 10 is addressing group 10 will be addressing
Group
RUVA.
8 is only doing time factor.
So we will take group 10 before group 9 here. Group 10 is
Yes.
on technique, group 9 is on a different issue. We'll take group 9 and group 11 together. But by now, everybody should have
No,
submitted their
sir. Group
paper.
11 is on exclusion.
Somebody said group 9 is on exclusion.
Yeah,
No, it's group
exclusion was
10.
divided into 2. Exclusion,
Oh, okay,
simpliciter,
okay.
and then public.
Okay, very simple.
Public.
Group 9 and group 11 will come together under exclusion, and we'll give them 1 hour so that we can use the remaining 1 hour to take personal connecting factor, the issue of the meaning of domicile, comparing it with nationality. Is that group 12?
Let me see.
What is group 12?
Yes.
You are talking about
Don't
personal connecting factor, isn't it?
group 12. Yes, sir. You're right, sir. Domicile,
So
nationality.
please get the timetable now. Next week, we take group 8. They say they are talking about incidental question and time factor. We'll
Group
give
7.
them.
That's group 7.
That's group 7. That's group 7, sir.
Okay, group 7. They say they are talking about incidental question only.
Yes, sir.
So we give them 15 minutes because most of the things they need to say in incidental question we have done. Just what we just need from them is the cases that the textbooks will normally present as their own conclusion, as the basis of their own conclusion, that this is what an English court will do. Knowing full well that we in Nigeria will do our follow, usual follow. That is what English court will do, that is our practice. Okay? 15 minutes, not more than 15 minutes. Then group 8 after them will present time factor.
Time factor.
Eh?
Yes, sir. Very correct. Time
We
factor.
present time factor, we give them 15 minutes and I will discuss it 15 minutes. Then group 10 will discuss RUVA because RUVA is a bigger issue. We'll give them 30 minutes and I will discuss it for 30 minutes. That's what we are going to do next week. The week after that, group 9 and 11 we will present in the first 1 hour, 15 minutes each. They will present whatever they have done on exclusion of otherwise applicable foreign law, and we use 30 minutes to discuss it. Then after that, the next 1 hour, the group on personal connecting factor, okay, that is likely to be group 12, would come in. By the time we get to that one, we will begin to feel safe that whatever I see that we cannot cover, I'm sure that after that one, the next topic is usually marriage. And marriage is broken into 2 lectures. Even if it is the first of the 2 lectures we are able to do, we would have done enough to write exam. And we will now decide what to do to those who cannot present. Okay? Is that all
Yes,
right?
sir.
So
Yes,
I
sir.
see you next week.
Thank you, sir.
Sir.
Yeah?
Sir. The
Yes?
class has been on my neck, sir. On the issue of materials that help us look for.
Yes, you people should have. Somebody reminded me truly, but
I
I don't know.
I did remind you, sir.
Okay. Before next week, I will look for any materials I have on the remaining topic and send them to you.
Okay. Thank
Is that all right?
Yes,
It's
sir.
okay, sir.
The
Thank you,
remaining
sir.
topic are the previous topic, sir.
Okay.
Yes, sir. Maybe all the topics, material that we can.
Okay. It's all right.
Thank you, sir.
I don't know why my mind is telling me that Prof will tell us the areas that will come out in exam. I don't know. My mind is
Wake up.
just working.
We're talking about areas that will come out in exam now. When we are
Yes,
just, I don't know whether we
it's
have done up
just my
half of
mind,
the
sir.
syllabus.
It's just my mind.
I
I know you.
normally do, but I cannot begin to know what will come out in the exam by now.
Okay,
Okay.
sir. God bless you, sir.
At least we first
God bless you,
focus
mighty.
before we examine.
Thank you, Prof.
Okay.
Class governor, thank you.
Yeah.
Doc.
Good night, everybody.
Good night.